April 12th in the Southern District of Illinois in East St. Louis. 4 consolidated challenges against Illinois' gun ban are going to be heard by a federal judge with the state as defendants in this case. We'll hear about kind of a preview. Thomas Maag, he is an attorney that brought the case out of Crawford County that was transferred from county courts to the federal courts. He's just one of 4 plaintiffs in that. But I wanted to give just a brief recap of the McHenry County case where McHenry County State's attorney is challenging the state's gun ban out of McHenry County that was transferred to from state court to federal court. Here is Assistant McHenry County State's Attorney Troy Owens talking about, a recap of a hearing they had yesterday in that Northern District case.
I can boil it down to this. You can distill it down to this paragraph effectively. The court wants to know that it has jurisdiction before it rules on the substantive merits of the preliminary injunction. We're about a week away from arguing that the PICA Act should be held unconstitutional in the Southern District as defendants. That argument's happening in East St. Louis next Wednesday. And there's already a case pending. I think the case is called Herrera. It doesn't involve us and it doesn't involve the Attorney General, but that case is already in the Seventh Circuit, and it's challenging the PICA statute. And I strongly believe whatever happens in the Southern District is, go to the Seventh Circuit.
So, again, Owens, he mentioned that not only is McHenry County in the Northern District of Illinois challenging the state's gun ban, they are also in the defense side in the Southern District. So it kind of puts them in a odd position.
Sure. It's a little weird. I mean, our position's the same. We in our deck action and our request for injunction, we said PICA is a violation of the Second Amendment, particularly in light of the court's decision in Bruin. We're the only defendant in the Southern District who's taken the position that the plaintiff's deck action injunction should issue because PICA is unconstitutional based upon Bruin. We just took an exception to whether or not Section 1983 and Section 88 should be applied against us for the purpose of having to pay their legal and costs. I don't think that they're actually aiming that at the McHenry County State's Attorney's Office, but the court can rule on the deck action, find it unconstitutional under the Second Amendment based upon Bruin, and not reach the Section 1988 issues. So we're in full agreement with the plaintiffs, with the exception of a very small part of it. So in terms of a principled position, it's the same thing. It's just, we got sued in one court and we're suing in another court.
So again, interesting to see the predicaments that the McHenry County State's Attorney's Office is in, because they're, plaintiffs in McHenry County against the gun ban, but they're defendants in the Southern District that plaintiffs have brought against the gun ban. Though they say as defendants, they support the plaintiffs' position in the Southern District. Back to the Southern District, though, Thomas Maag, we talked with him. He's the attorney from the Crawford County case that was transferred to federal court, and he's just one of 4 plaintiffs groups. You've also got the National Shooting Sports Foundation, the Illinois State Rifle Association, and the Federal Firearms Licensees of Illinois, all in that consolidated case down in East St. Louis. Is going to be heard April 12th. Maag shared with me a bit of a preview he sees happening.
I think it'll be a rather straightforward hearing. Of course, the plaintiffs, the plaintiffs in each of the cases have the burden of proof, as they're the plaintiff. I would imagine Judge McGlynn will come out on the bench, go through the normal greetings, go on the record, basically explain the procedural posture for the record, as that's what's normally done, on the assumption that matters like this will go up to a higher court.
And that is expected that this is going to be going up on appeal, even in the Southern District, where the case is going to be heard April 12th. But it's just against the Second Amendment arguments. One thing that Maag's case was different than the other cases in the Southern District is Maag's case dealt with the allegation that it violated Fifth Amendment rights, that you don't have to incriminate yourself by telling the state you have a gun that they deem illegal. He says those are being put on hold at the moment so the Second Amendment issues can be debated.
That's not part of this particular argument in order to speed this particular motion hearing through, we agreed to delay our Fifth Amendment argument and another argument until a later date if it became necessary to argue those as well.
And then Maag also talking about how hyperbole doesn't violate or doesn't amend constitutional rights.
Sure. The state in their brief made reference to comparing these firearms at issue in the magazines for them to hydrogen bombs, literally. And made the reference that these firearms were developed after the invention of the hydrogen bomb, which, of course, factually is largely not true. These types of predate the nuclear era anyway, but to compare a gun, a firearm, to a hydrogen bomb it is so far out of the realm that I can't believe that a lawyer actually wrote it. I mean, that tells me the governor himself or the attorney general himself is just playing politics with this.
We'll have more as we follow this all throughout.
From the Fly